Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have more than 6 hours of argument time requested this afternoon, so please keep that in mind as I call the cases. Understand that we have your briefs, we have the full record, we are fully familiar with the facts of this case. So please ask only for the time that you need in order to make your most important points. Okay. I'm going to call the calendar, starting with People versus Victor Gimenez Cepedas. 4, 2, and 3. Thank you. DeWald versus DeWald. So you're not going to argue? Thank you. That's a submission. Thank you very much. Pascal W. versus Carlos M. is submitted. Gerlach versus Marino. Give you 6 and 6 and did you want rebuttal? You didn't ask for rebuttal. Okay, 6 and 1 and 6. Torres versus Lens Crafters.
Good afternoon, Your Honors. Name Drexler for the appellants requesting 5 and 2. Good afternoon, Your Honor. The defendant responded 390, 4 minutes. Good afternoon. For plaintiff responded 4 as well, please.
Okay. 5, 2, 3, and 3. Thank you. BA versus HK is submitted. People versus Odalis Imbert. People versus Odalis Imbert. Submitted. 120 Main Hotel versus Sampo America Insurance.
Good afternoon, Your Honor. William Cooney, the appellate, requesting 12 and 3, please.
Good afternoon, Your Honor. Natasha Romioli, the respondent, requesting permission for my colleague, Mr. Thomas, to argue the appeal and requesting 6 minutes.
6, 2, and 6. Thank you. Cincinnati Terrace versus Tarter, Krinsky, and Drogan.
Good afternoon, Your Honor. Mario Biaggi for the appellant, requesting 8 and 4.
Who's the appellant?
Good afternoon, Your Honor. Rob Bergson for respondent, Tarter, Krinsky, and James Smith. 3 minutes, please.
Anthony Duffy on behalf of the remaining respondents, 5 and 2.
7 and 2, 3 and 5. Smith versus Consolidated Edison. Submitted. Tartell versus Klein.
Good afternoon, Your Honor. 8 and 2 for the appellant.
6 minutes, Your Honor, for rebuttal.
6 and 2 and 6. Moy versus Mount Sinai Hospital.
Your Honor, for the plaintiff's respondents, appellants, request 6.
5, 2, and 6. Wilmington Savings Fund versus Abatusen.
Good afternoon, Your Honor. Michael Falkowski for the appellant, requesting 5 minutes.
Is there a respondent here?
No respondent.
Do you want to argue against yourself, or do you want to submit? I mean,
If the court had any questions, I'm happy to answer.
I think we'll be fine with a submission, if that's what you... Thank you very much. Owens versus New Empire Corp.
Good afternoon, Your Honor. Request 6 minutes.
Respondents also request 6 minutes.
6, 2, and 6. People versus Anzar Thompson.
Appellant requests 8 and 2
5, 2, and 5. Thank you. Seymour versus Hovnanian.
Neil Omorahu for appellants. I asked the court to remember that there are 3 separate orders on
I'm very well aware. Thank you very much.
asked for 9 and 4.
For respondents, I will also ask for 9 minutes.
6, 2, and 6. Thank you very much. You didn't ask for rebuttal. Did you want rebuttal? I'm sorry. Your appellant and your response, yeah, your appellant, yeah. Did you ask?
Granted me 2 minutes.
I wasn't sure you asked for it.
Oh, I did.
Oh, okay, all right, thank you. 6, 2, and 6. Okay, first case for argument, People versus Victor Gimenez Cepedis.
Good afternoon, Jane Merrill for appellant Victor Gimenez Cepedis. May it please the court. Mr. Gimenez Cepedis was charged with the sale of fentanyl. The indictment could have been written more broadly to accommodate the facts of this case, charging him simply with the sale of narcotics. He could have been charged with attempted sale of oxycodone.
But this was a jury trial.
Yes, sir.
And you're challenging the determination, which is, a defense was based completely on the credibility. And I'm not sure what basis you have to overturn the jury's determination.
Your Honor, the credibility, if Your Honor is referring to the credibility of my client who testified, you don't need to find, the court does not need to find him not credible to find that this verdict was against the weight of.
But if the jury found the people's witnesses credible, wouldn't that, how does that affect your argument?
I think you can credit every witness, Your Honor, and still find that knowledge simply was not proven here based on the facts as.
Can
as we
the
all
knowledge
agree
be
on.
inferred from the possession?
There is a rebuttable presumption of knowledge, but here I think the facts rebut that presumption.
But your client's argument was that, or defense was that he thought it was jewelry in the box, not pills. Then there were only pills in the box, and the video shows that the pills were open when he was in the car, I believe. And then it changed from, well, the pills weren't fentanyl to the pills were oxycodone. So how do we get from jewelry that he says that was only jewelry in the box to then now we have a new defense with regard to pills versus what kind of pills?
Your Honor, I think the record shows very clearly that my client's decision to testify was a very last-minute decision. It's discussed on the record. And I don't think you need to credit that he thought it was jewelry. It's clear that he was aware that this is some sort of illicit transaction, no question.
But he testified to that.
He testified to that. But this is not an affirmative defense. It is not defined by statute as an affirmative
But he
defense.
testifies he's working for Alex, and then it turns out that he's dealing with Galactico. So the story that he tells makes it very hard to refute the inference that he knew it was fentanyl.
Your Honor, these were counterfeit pills. So even if he had known had opened the box, had opened the packages within the box, opened the tissue paper within, he would have seen blue pills, which are visually indistinguishable from oxycodone. The pill and its counterfeit, indistinguishable. So even accepting that he had opened the box and even rejecting his testimony as totally not credible.
But what is in the box? What is in the box?
What was in the box was fentanyl pills that were disguised as oxycodone, Your Honor.
And to take that, I guess, to its logical conclusion, because he was charged with specifically fentanyl, is that where you're saying the knowledge didn't come in?
Exactly, Your Honor. The indictment charged specifically fentanyl.
But what he brings is fentanyl.
It is fentanyl. It was disguised as oxycodone, Your Honor. So I think at most, the proof here shows that
Disguised for whom?
disguised for the purpose of sale generally. I think that was the testimony that oxycodone, counterfeit oxycodone is frequently fentanyl.
But when the jury comes to the conclusion that he knew it was fentanyl, what is there about their determination that seems amiss?
There's no question, Your Honor, that it was fentanyl. The question is whether he knew it was fentanyl. This is reckless sale. This is perhaps attempted sale of oxycodone. It's even conspiracy. But whether or not he as a layperson with absolutely no criminal history, no prior involvement in the drug trade, could do what a chemist could do, which is distinguish these two on site, is unquestionably not established. Thank you.
Good afternoon. May it please the court. Margaret Crookston for the people. Here, the jury's verdict did comport with the weight of the evidence. The facts of the...
What about counsel's last point, that no one would be able to tell that it was fentanyl because it was disguised to look like oxycodone, the pills,
Yes.
the description of the pills?
Yes, Your Honor. And the jury heard all the evidence and all the testimony of that these pills are frequently made to look similar and that they are similar in appearance. However, because of the other factors here, which is the fact that defendant was in a prolonged possession of the pills, he was in charge of executing this sale. He
didn't open the pills prior to him having them?
He testified that he did not know. They were in his possession in a very loosely taped box for between 8 to 10 days.
Could you see the pills through the wrapping?
So once the box was opened, you could see, it was like a tissue paper where you could see the bumps on the outside of the package to show that there were pills inside. But you had to push the pills through the paper to see the pills themselves, but you could tell from the internal package that they were pills. So they were able to tell, and the fact of the price of the pills, they were being sold for what is typical of fentanyl pills, which is $2.50 a pill. That being said, defendant had said he had one-on-one conversations with Galactico arranging the sale. He was the primary person in charge of selling them, in charge of getting and being trusted with the $25,000 in cash. And there is the
defendant was going to pick up expected to pick up $25,000, right?
Yes, yes.
That wouldn't be unusual for jewelry, if he believed it was jewelry until the moment the box was opened.
Yeah, I guess that's true. He did testify he never saw any jewelry in it. I think it's unlikely that that amount of jewelry would fit in that box. There was it wouldn't really make sense, and especially once he opened it.
But there is this discrepancy in the defense that the defendant says he's working for Alex, and it turns out that he's working for Galactico.
Yes, yeah, there was no, besides defendant's testimony that he had known Alex for a while and he had gotten him in contact with Galactico, but other than that, there's no information that we have about Alex being involved in the transaction beyond that. So yeah, with the inference, I think that it was failed to be rebutted by defendant's testimony. The determination of the jury was within the weight of the evidence. If there are no further questions. Yes,
Thank you.
Thank you.
Your Honors, price is a reliable signal only if it is known. Here, the prosecution had ample opportunity to elicit whether or not Mr. Gimenez Cespedes knew the total amount he was supposed to receive as a result of the transaction. That was not established at trial, nor was there any proof that Mr. Gimenez Cespedes knew the number of pills in the package, which in fact differed substantially from what the agreed upon, the negotiated deal had been. And he played no part in those negotiations. So the high price of the transaction here alone simply does not get us any closer to establishing knowledge. My adversary casts Mr. Gimenez Cespedes as a critical member of a drug organization, integral to its operations, savvy and street smart. He was nothing more than a mule. This man was a rice farmer for 50 years before arriving in the United States. He'd recently gone bankrupt, moved to New York, and was selling used clothing and shoes on the streets. What Galactico said to the undercover was true. The old man was scared. Under the circumstances, the evidence showed that Mr. Gimenez Cespedes sold fentanyl recklessly, not knowingly. The prosecution here assumed a burden that it simply didn't meet, and reversal is required. Thank you.
Thank you both. Sherlock versus Marino.
Good morning, Your Honors. Good afternoon, sorry. Andrew Ross for Appellant Michael Marino. So as the court is aware, there are 4 issues to be
Yes, and I'm just
decided.
going to start with just asking you a question so you can put it into perspective. Your clients raised all of the issues, these four issues that you're talking about, that the investment strategy was good, that there's a question about the discretion and that she violated the EPTL, that she overpaid herself, that she failed to collect taxes. So don't all of these, I said your client, but I didn't mean that, sorry. Don't all of these factors raise an issue of fact and require trial?
No, I don't think that they.
So what is there to definitively,
okay.
as a matter of law?
If I may, sure. So with regards, I'll start with the negligence.
Failing to promptly wind up and distribute the estate. Why don't we start there?
Right, to promptly wind up and just thank you, Your Honor. So why is there not an issue of fact here? So the court found that we had made out a prima facie entitlement to summary judgment based upon the 5 or 6 years of where the estate ran very large deficits in its operations. The court saw that and said, okay, they should have sold after those 5 or 6 years.
Right, but then
Right.
on the other hand, there was a question as to whether or not what she did was good investment strategy, and that the will gave her broad discretion.
Right.
Those are viable claims and issues. So how did you, as a matter of law,
If I may.
eliminate any issue
If
with
I may.
regard to that?
So we completely agree that the will says what it says, that she could hold on to this she could hold on to non-productive assets. We agree. That's what the will said. So the issue is that we brought up in our memo in his affidavit that EPTL 11-1.7 says that there cannot be any exoneration for someone's imprudence. So the
Right, but
judge...
the issue of whether or not it was prudent is a factual issue, because there are things that need that at least what's in the record right now point to it might have been a savvy business or unsavvy business, maybe renovating the apartments to get a better resale value, waiting for the market to improve. And these are things that can't be decided on paper as a matter of law. That is a factual determination for a trial.
Except that the judge made a finding of imprudence. She said, you made a prima facie entitlement to summary judgment on the issue of prudence because of these 6 years where there were these very, very big
Counsel,
operating
you
losses.
forget the other part of the decision where she found that there was a question of fact with regard to the prudence, whether or not it was savvy or not savvy. So once you meet the prima facie, it doesn't mean you get summary judgment. Let me finish, please. The other side then has to proffer proof, which they did, and the surrogate below found that's an issue of fact.
But she didn't say that there was an issue of fact in the decision. She did not say there was an issue of fact with the prudence. She said there was an issue of fact because the will said that she could hold on to this.
I believe she said both, and then that the issue of negligence would have to come for the jury. She didn't say that it was exonerated. She said even if there was still an issue of fact as to negligence.
I read her decision differently from the way you're reading it, Your Honor. I don't read it as her having said that there's an issue of fact with regard to prudence. I read it as her
Regardless of what the surrogate may have said, why isn't there an issue of fact? The executive says, look, the market was depressed, the properties were in need of renovations, I got to work on making those renovations, and some of these things I sold at enhanced values as to what they were worth before. Why doesn't that create an issue of fact?
Because there were 6 straight years of tremendous operating losses, which didn't affect, the operating losses had nothing to do with the value, the fair market value of the properties. In other words, the fair market value of the properties, which in the chart I had submitted, I used the fair market value. I didn't discount them on account.
Well, they're operating losses, but if I sell now, I'm going to get much less for the property than what it's worth. So yes, it may generate an operating loss now, but at some point in the future, I'm going to enhance the value of the property and make up the operating loss and make profit with it.
Yes, but by the year 2013, when these 5 years had expired, the recession had largely corrected it.
And what happened after that? Isn't her very point that after that, she did sell these properties at greatly increased values?
There weren't that many properties left, but she did in fact sell a property in Beacon in the year 2019, I believe, which made a very excellent profit. We're not disputing that. What we're saying is that after that 6 years, she should have liquidated the estate. And that's what the Hubble case says, that if you have 6 years of really tremendous operating losses, those are considered non-productive assets.
Thank you.
And,
You'll be able to elaborate further on your rebuttal. Thank you.
Okay. Oh,
You have some rebuttal. Yes, your time, that red light means that.
Thank you.
Good afternoon. Amy Altman for the respondent. The question of whether or not a fiduciary has acted prudently is a factual determination to be made by the trial court.
What should we make of your adversary's position that the surrogate, in making her determination on the issue that we're discussing, whether or not it's prudent or not, pointed to the provision of the will and didn't necessarily say there's an issue of fact?
So the surrogate aptly provided that there is an issue of fact for 2 reasons. First, the will has Article 13G, which allows broad discretion. Article 13G is a retention clause. It is not, as objectants state, an exoneration clause. What it does is it allows the fiduciary to retain the properties so that there wouldn't be a need to diversify the minute that she became fiduciary. Had that happened, then there would need to be a total fire sale. And so Article 13G was one issue of fact that the surrogate aptly pointed out. And the second issue of fact is the evidence that was provided to show that certain of the properties, when they were sold, had increased in value almost 80%. And so in the matter of In Re HSBC Bank, that case also talked about retention clauses and how they are not exoneration clauses and how it does give certain deference to a fiduciary to hold on to the inception assets, but it never relieves the fiduciary of their duty of prudence and duty of ordinary care. So the issue has been reserved for trial, and if it turns out that by retaining the assets there was a loss, then that is something that the fiduciary will be held accountable for. But EPTL 11-1.7 does not apply. It's inapplicable in this particular matter.
Thank you. Thank you.
Well, the first thing I'll say is Ms. Altman said, that the evidence showed that there was an increase of 80%. That was nowhere in anybody's brief, anywhere on the summary judgment motion or on, well, it wouldn't be in the appeal if it wasn't in the summary judgment motion. So I first have to address that point. I'm not sure what the significance.
What's your response to your colleague's reliance upon 13G, which uses the phrase any period of time whatsoever?
Yeah, I'm not disputing that that is a standard you can hold on to non-productive assets clause. I think that there's no cases that would ever say that that is not also an exoneration clause. That in other words, the person who's holding on to those assets cannot, that clause states implicitly that that person who is holding on to those assets cannot be held liable in negligence or imprudence by the objectants, by the beneficiaries. I believe that and that's where 11-1.7 and Hubble come into play here, which is that New York, which is the only state really that has this anti-exoneration policy, steps in and says, we don't honor those types of clauses. So yes, she did have, permission to hold on to them. But again, and Ms. Altman basically said this, that she's still subject to the rules of imprudence. But the point is that she could be held liable if indeed her behavior violated the Prudent Investor Act.
Thank you. That all sounds like questions of fact, but thank you very much.
Thank you.
Thank you both. Torres versus Lens Crafters.
Good afternoon, Your Honors. Nate Drexler for the defendant appellants 338 West Broadway Condo and Epic 386 LLC. I'll refer to them collectively as the 386 through 388 Broadway defendants. Your Honors, this case turns on a very straightforward rule, that is Administrative Code 7-210.
So 7-210, I think, shifts liability from the city to the owners of the abutting property. Isn't
That's
that right?
correct.
And so I'd like to ask you how 388 has established that it didn't cause or create the alleged defect, since their predecessors, I believe, are the ones who created the ramp that made the sidewalk uneven, and that was not addressed at all. So how are they not responsible or involved?
I would argue that the evidence it bears this out in a number of ways, Your Honor. First and foremost, the testimony of 386, 388's Superintendent Mustafa Maroof, who the day before his deposition, I believe he was deposed last, took photographs of both properties, and those are found in the record at 426 through 434. It shows that 390 West made the repairs to their sidewalk, including the ramp, and including the joint. And the nature of the repairs is what's compelling here, Your Honors, because what they did was brought their sidewalk up to the level of the 386 through 388 sidewalk, which was always perfectly flush with the granite curb in front of them. There was no curb on 390. So
You said those pictures were taken the day before the deposition. When is the relationship between that and the date of the accident?
well, the relationship, Your Honor, in our opinion, is that it proves that 390 West controlled that sidewalk. They controlled the area where the defect was. They controlled everything about it.
What year was the accident?
Excuse me?
What year was the accident?
The accident.
And month?
I don't have the year in front of me. I'm sorry. 2016.
And when was the deposition?
It was 19. It wasn't until 2019.
So we're talking about a...
3 years.
Yeah, they waited 3 years to fix their sidewalk. That's correct.
Okay, well, we're talking about what happened at the time of the alleged accident where the person tripped. And at that time, the sidewalk was repaired by 388's predecessor. I mean, isn't that right?
The sidewalk was placed by 388's
The ramp.
predecessor. The ramp, yes, that's correct.
Right.
The defect,
So at
though,
that time, the neighbors hadn't changed it. It had not been changed since the predecessor to 388 put it in. Isn't that right?
it was still, because of the nature, because of the statute, and that the defect itself was abutting 390 West, it's always their liability, Your Honor, under the statute, under Administrative Code 7210.
So you're arguing, let me see if I understand this. Your predecessors put it in, and then they did nothing to it, but the ramp was placed by 390, and because they repaired it after the accident?
The ramp was not placed by 390. The ramp was included with what was laid by the predecessor, so it was there. The ramp was there, though, because the property at 390 was below the level that the 386 to 388 sidewalk was, which was, again,
But the height difference was because of the way your predecessors put in their sidewalk?
respectfully would disagree with that position. The photographs show that since the very beginning, the 386 to 388 sidewalk was always perfectly flush with the granite curb on the street. It was never raised above.
If you look at the picture at page 419 of the record, if you're familiar with that, it clearly shows that there's a ramp between the two properties. I mean, you take a look at that, and I think one's reaction reasonably is, well, they're probably both responsible for that, especially since there's a defect in the ramp. There's a piece broken out of it, which is very possibly a tripping hazard. It's almost whoever put this in has created a situation which creates a possibility of tripping someone.
Your Honor, the ramp was only ever put in because of the lowered nature of the 390 West, which they essentially conceded because when they fixed the issue, the defect, the ramp, the joint, and the sidewalk, they brought it up to the...
Who put in the ramp?
The predecessors of my clients.
And so I see that you want to rely on 7 to 10 as a way to say, well, that says whoever has the sidewalk that's, whoever owns whatever the property is right in front of that. But there's more to this when there's a question as to who fixed that piece that extends into the next space. I mean, it does sort of go over both pieces. And so as my colleague just indicated, it's possible that both parties are responsible.
Well, Your Honor, I mean, relying on the statute, that's not correct because it's only it draws a bright line at abutment. And
I said you want to rely on that. I
Oh,
thought
that's
you were
correct.
relying
Yes,
on
I
that
do.
solely.
We're also relying on the fact that the repairs were made that demonstrates that
But you
390
put in
West
the
had
ramp.
control.
By your client, the repairs that led to the ramp being put in were made by your client. The repair that was made by your adjoining neighbor were made long after this accident occurred. So so it seems to me that what you're creating is a question of fact that
I want to make sure I caught you correctly because I think you said my clients created the condition or put the ramp in, and they did not. It
your predecessor.
predecessors did. That's correct.
Right.
Nonetheless, it's not abutting their property, and the fact that it took 390 West 3 years to repair it
So
should
counsel,
affect liability.
You put in the ramp.
The predecessors.
I understand that, but it's not unreasonable for you to be charged with that. You put in the ramp, and the fall is arguably resulting from the ramp. And I understand you're saying the ramp is not on your property, but if you put in the ramp, why shouldn't you bear at least some responsibility for that?
Because that's not what the statute dictates. It's not what the statute provides. There's just simply no leadway in the statute to impose.
If you actually create a negligent condition on the sidewalk, you're not responsible for that?
I think if we take it to its logical conclusion respectfully, then we could take that all the way down the block to every...
Except no one fell down the block. They fell there, and they say it's the incline of the ramp.
They fell on your ramp.
Is it your position that because it's placed on the abutting property owner's sidewalk, it doesn't matter who put it there? It's on their sidewalk, it's their problem?
The fact that it was there was because of the flaws with the 390 West property to begin with.
I think your answer to that question is yes, and we'll hear more from you on rebuttal.
Thank you, Your Honors.
Good Good afternoon. May it please the court, my name is Tom Keene. I represent the defendant, respondent 390. It's 388 and 390. I have a hard time myself. This is a height differential case caused by their pour of a concrete sidewalk in 2002. They poured it in 2002. They poured it too high. It never matched. So what was their solution? Their solution was not dig it back out.
Yeah, but at the same time, there is this dangerous ramp, and I grant you that they seem to have created the ramp, but there is this dangerous ramp on your property.
I'm not here to get me out today. I'm here to keep him in.
Okay.
That'll be another day perhaps. But today I'm here to keep him in because he put the defect on the sidewalk. I don't even want to call it my property. The sidewalk that's outside
You
my
may not want to call it your property, but it sounds like it is your property. It sounds
In
like
the
it's
greatest
your
city in the
client's
world,
property.
Your Honor, in the greatest city in the world, I think that the city should be able to take care of its own sidewalks. But no, you're right. For the purposes of 7-210,
Okay, that ship
this
has
is
sailed.
this is my sidewalk. But he did dirty on my sidewalk, and he expects me to clean it up. And while the plaintiff may be able to say, yeah,
But
Tom,
ultimately, didn't you clean it up?
eventually, 3 years after the accident, we said, well, you're never gonna fix it, so you're never come down, so we're gonna come up.
Because the city is going to come after you.
Everybody's coming after me.
Anyway, anything further?
No, thank you.
Thank you.
Good afternoon, Your Honors. Santiago, Blaze, and Zaborovskia, I think I got that one correct, it's in our papers. They're the second department cases that show that Sangre applies to height differentials between adjoining property owner sidewalks. That's what we have here. The responsibility to remedy the dangerous condition, the responsibility to remedy the height differential is not just under Sangre as by 7-210 on the property that's in front of. It's also as to the adjoining property because the height differential is between those two properties. So here, what they
Therefore, I would suspect the implication of that is it's almost always, if there's a height differential between two properties, there must almost always be a question of fact about how that got there or how it got into a situation where it was problematic for passersby.
Sure, generally, and absolutely in this case. But I would say that even in this case, this is a step further than that because we know that they created it when they poured their sidewalk too high. The easy answer to this would just shave down your sidewalk so it matches. If you're going to create a ramp that's not so stark. That's not the 2 to 3 inch tripping hazard.
They added that sidewalk to the existing sidewalk at, I guess, 390? Is that what happened? They redid their sidewalk, and when they redid their sidewalk came out higher than the adjoining sidewalk.
Correct, Your Honor.
And to correct that, they put in the ramp.
Yes, Your Honor.
Which then went into 390's property.
100%. That is exactly what happened.
And which then seems to have developed a defect in that a piece of it is chipped out close to the curb.
Yes. And unless there's any questions, I'll rest on my brief.
Thank you.
Be very brief, Your Honors. This idea that my client's sidewalk was too high is not established.
But do you agree that the ramp created by your client's predecessor was not only in front of 388, but also was in front of 390?
The ramp was only on 390.
Okay. So then there's no dispute that your client's predecessor created that ramp so that if you created a ramp that was defective, suppose it had a huge hole in it, wouldn't that cause you to have some liability if somebody fell into that hole?
Not if my client's sidewalk is perfectly flush with the rest of the surrounding areas, including the granite curb, including the neighbor on the other side.
You could do anything to the sidewalk in front of the adjoining property and not be liable for it?
Pretend for a second, Your Honor, that my predecessors did not do a ramp whatsoever. They just placed their sidewalk completely flush. Would it not be 390's issue then to bring their sidewalk up to the
Well, we're not dealing with that. We're dealing with the fact that in fact, your client's predecessor did something that affected the sidewalk in front of 390. And And hypothetically, if you had done that with a hole in it, someone fell into the hole, you don't think you'd have any liability for that?
The statute does not
The
allow for that.
statute doesn't apply to this. The statute applies to the liability as between the city and
Yes,
and
but
the
it,
property owner. It doesn't, excuse me,
sorry.
I don't, if you could tell me where the statute defines liability as between two adjoining property owners, I would find that helpful, because I don't see that in the statute.
It is a non-delegable duty, Your Honor, regardless of who put the sidewalk in,
Where did,
and liability only attaches to the owner.
So, counsel, isn't it true that we have, I'm sorry,
go ahead.
isn't it true that we have case law, Delgado and Jennings, that says the opposite, that even if the sidewalk belongs to 390, you still have a duty to maintain it, notwithstanding that. Look at those two cases.
It's our position, Your Honor, that the sidewalk was always perfectly maintained. It was perfectly flush with all the other surroundings
It did
except
not
the
look
lower
like it
side.
was maintained. That's why the plaintiff fell.
It was not, the part that was not maintained was the responsibility of
I think
390.
everyone realizes it was not maintained. It was admitted by the superintendent it was not maintained.
I thank you. We have your point.
Thank you very much, Your Honor.
Thank
Have a
you
nice
all.
day.
120 Main Hotel versus Sampo.
I didn't know he was still.
Good afternoon, Your Honors, and may it please the Court. William Cooney for the appellant. The hotel's vacancy and unoccupancy is not in dispute, and the insured plaintiff has not and cannot allege a cognizable cause of action.
So I want to get right to it and ask you about this, the language in the insurance document, which says, it talks about it being vacant or unoccupied, because it seems like that's at the heart of this appeal. And the question is, what does that mean? Because both you and the plaintiff seem to define it differently, and the policy is not particularly clear. So the question raises issues of fact, it seems, as to how this definition of vacant or unoccupied should be defined.
So the reason it's not there's not a question of fact here is because they have alleged only one way, one circumstance in which they can find that the property is vacant or unoccupied. The way the statute works, it's not legally sufficient for them to allege that the hotel is occupied and not vacant. And so I would refer the court as well to the McCabe decision for the fact that the court here has to look to the plain meaning of
Well,
the
you're
words
right.
vacant
It's
and
not
unoccupied.
enough for them to say it's vacant or unoccupied, because it seems that vacant or unoccupied is not where it ends. As long as you can maintain fire protection and watch and alarm services at the premises, then it might fall under vacant or unoccupied.
But they did not maintain fire services, and they did not provide the required notice.
Well, it seems like Mr., I don't know that I'll remember his name, but Melenda, the Melenda affidavit seems to indicate that they did just that they had maintenance of the security system, that the Rochester Fire Department's had inspected the fire system, that they maintained watch services, that his personal review of the video, he personally reviewed the video surveillance from around the time of the fire. I mean, he says that they were notified by their alarm
Let me
system.
refer the court to paragraph 5 of Mr. Melenda's affidavit, where he says,
Speak up, please, I'm sorry.
I'm sorry, paragraph 5 of the Melenda affidavit indicates that the property, it's a concession, it's an admission, that the property's internal fire pump was inoperable at the time of the fire. They did not maintain the fire protection system of the hotel. So as well, the insured has admitted that not a single commercial overnight guest
But
stayed at the
Melinda
premises.
doesn't say that the fire alarm systems is what notified the Rochester Fire Department of the fire?
Excuse me?
Melinda doesn't say that the fire alarm systems is what notified the Rochester Fire Department of the fire?
But that doesn't matter, Your Honor, because the policy provision it requires the insured to maintain the fire protection system, whether
How would it be then not maintained if that's the system he said that alerted them? He says his system alerted them.
So perhaps that part of the system functioned, but again, there's more to it than that. And the fact that they had an inoperable internal fire pump means that they failed to maintain fire protection system.
But this sounds like it's an issue of fact. He says it maintained. You're saying on some basis it didn't, but it did call the fire department that came to put out the fire. That sounds like a discrepancy in a determination of what that maintaining that system is.
As to perhaps to the alarm system, Your Honor, but there's more to it than that. The fire protection system was not maintained. And as well, it's important to understand the insured has not.
I have to grant you that there is a considerable amount of evidence here which supports your position that, in fact, the hotel was vacant and in disrepair and not being used. But we're talking about a 3211 motion, and isn't there enough for purposes of a 3211 motion, we're not talking summary judgment, I stress, isn't there enough for that to keep this case going? Because even the letter from Boswell Eason declining coverage says, it is our further understanding that Alden Favoro of National Fire Judgment claimed that the hotel was used for COVID-19 quarantine as recently as 2 months prior to the claim. And then there's the claim by the plaintiffs that there are rooms that were ready to be used for hotel purposes, there was liquor on the premises, there was a computer set up so that they could do key cards if they needed to. So isn't that enough, if perhaps just barely, but in terms of a 3211 motion, that it doesn't get granted?
I disagree, Your Honor, respectfully, and 2 points on that. First, the presence of liquor does not a hotel make. And second,
That's probably the weakest thing, that there's liquor. But there is a key card, the machine to get into the rooms, there's the key card, and the beds are made, and it's a number of floors.
And they're linen and towels. These are all things that go with the hotel.
but most of a large a plurality, at least, of the rooms were not in any condition of use. But more
Weren't there
importantly,
3 floors that the beds were made up? ready
service
to go?
elevators were not functional. They couldn't have gotten room service to any of the rooms.
Well, there was stairs,
Windows
right?
were boarded up.
A hotel can operate without room service. That wasn't a requirement of the insurance, right?
That wasn't a specific requirement. That's correct, Your Honor.
There could be room service by somebody walking up the stairs, right?
In a commercial hotel,
Thank you very much. Thank you. We're not asking whether you would have wanted to stay there,
It wasn't 5-star
or anyone in this room, for that matter.
Good afternoon, Your Honors. David Thomas for the plaintiff and respondent. The issue here is simply whether the respondent's interpretation of the first part of the vacancy provision, that whether a insured building is considered vacant or unoccupied when it does not contain adequate covered property to conduct customary business operations, whether construing that to be the exclusive definition of vacant.
But picking up on what your colleague said, I mean, it's really pretty hard to think that, how many story building was this?
I believe it was a 15-story building.
How many?
15.
15. It's really pretty hard to think that that building is being operated as a hotel without working elevators.
Well, the key point is the definition here is adequate covered property. And the affidavits of Mr. Favreau and Mr. Melenda established that these were basically quick fixes, that this is an issue of fact. And in fact, that is exactly what the motion court found, that there was sufficient evidence in the record, and we will show, as we proceed through summary judgment and trial, that in fact, the hotel could have gotten up and running very quickly. There were credit card machines in effect.
But it hadn't been running.
It had not, but that is one of the key points here, because the Sampo contended that because the hotel was not in use as a hotel at the time, that meant it was vacant or unoccupied. That's not in the definition here. In fact, in one of the cases that they specifically cited, the Karen Havignon case, there was a definition of vacant or unoccupied in that policy that said it had to have been used at least 31% of the square footage. No such definition is here. It's just adequate covered property. It's a quintessential fact determination. But I want to get...
Conduct customary business operations.
Yes, Your Honor, customary business operations, but it's adequate covered property. And as the Melenda affidavit and the Favreau affidavit established, you could have gotten up and running very quickly. They basically, Sampo took a bunch of photographs, construed everything in the worst possible.
So if somebody called that morning and said, I'd like to rate, what were the floors? What were the 3 floors?
I don't
where
recall
the beds
which specific
were?
3 floors.
So it was a hike. It wasn't on the ground floor.
It wasn't on the ground floor, but they could have easily gotten up to there. The beds were made.
I understand, but I'm saying the idea, Mr. Person whose affidavit it was, said, and you're saying that it could have been done, they could have provided immediate service, essentially.
Very quickly.
Very quick service. So if somebody called that morning and said they wanted to stay there that evening, you would have been able to get the food prepared, the elevator working.
Yes.
For this person to get up to whatever the floors were, which I think one was 9 or something like this.
That's correct, Your Honor. There was certainly support for that they could have gotten operations going fairly quickly. And that's what we're talking about. But that's an essential factual determination that's supported by Mr. Favreau and Mr. Melenda's affidavit. But we need not even reach this because this is a 3211A1 and A7 motion. That's critical because the first part of the vacancy provision is what Sampo contends to be a condition precedent to coverage. Now, we disagree because actually the first part of the vacancy provision doesn't even have the requisite language for a condition precedent for coverage. It has language talking about a condition precedent for permission, but not condition precedent for coverage like other provisions in the policy. So even if they want to complain as much as they want about satisfaction of this first part, it's irrelevant. We don't lose coverage. But even if they're right, 3015, CPLR 3015A says, and it's made clear by this court's decisions in the Alice Chalmers case and the Warner licensing case, that we need not plead the sufficiency of a condition precedent. So they cannot obtain a motion to dismiss on failure of a condition precedent. That's dispositive. So we don't even need to reach any of that. On the second part, which is the exclusion, there was no sufficient documentary evidence. The Simplexium case from this court makes clear that when you have an all-risk policy like we have here, it is Sampo's burden to establish that the vandalism and malicious mischief exclusion applies. That's the second part of the vacancy provision. And they did not provide anywhere near sufficient documentary evidence. It's entirely a disputed issue of fact. They want to raise that on summary judgment, perhaps, but absolutely not for a motion to dismiss.
3211, I understand. Thank you very much.
Thank you very much.
A1.
Your Honor, if I may, I just want to make one point in response to Mr. Thomas's argument. And you heard him admit that the hotel was not, in fact, ready at the time. And we're not to look prospectively.
I didn't hear that. I heard that it was not ready, but it would be up and ready.
Yeah.
That's what I heard.
But the policy requires the hotel to have been in an occupied condition within 120 days before the fire. That's what they can't do.
Yeah, but the description is, when you talk about ready, they're saying that they could have put someone in the hotel right away. So the things that, there were stairs, the elevator wasn't working, they're saying they could have gotten it to work within that period of time, but there are stairs. So this is a very technical document. It says certain things here. And the question is this satisfied on a 3211 without issue? There are no issues here that require a determination, no fact issues that require determination?
Your Honor, I think it's very clear that it is the regular presence of inhabitants that makes occupancy, and their failure to allege that should be dispositive.
Thank you. Thank you both. Cincinnati Terrace versus Tarter, Krinsky, and Drogan.
Yes, good afternoon, Your Honor. Mario
Just a minute,
Biaggi.
please.
I'm sorry, Your Honor. Mario Biaggi for the appellant. The first issue that we would submit is that the doctrine of res judicata does not apply to the bankruptcy court proceedings or the district court proceedings for a variety of reasons, one of which it's an equitable principle, and you must come to the court with clean hands in order to apply it. I think if you look at the complaint, which the court is constrained to accept the facts as true, you'll see that the allegations are such that there was misrepresentations as to any potential claim to this property.
Because as to the res judicata, I think that the Ohio judgment wasn't conclusive as to TDK and to Smith's liability. That's in res judicata you're speaking about.
Well, the res judicata, it was they applied it to the bankruptcy court proceeding,
Right.
and to that district court proceeding.
And with the bankruptcy was not conclusive, so.
That's kind of the fallback position. The initial position is that the overall principle itself shouldn't be applied because they come to this court with unclean hands, and it's an equitable remedy, and they shouldn't be allowed to do it. Then if you allow them to proceed to analyze those two cases, you'll see that the bankruptcy court proceeding was never completed. There was no final plan of organization. It was dismissed because of a bad faith filing, so they don't get the benefit of that beyond that. As far as the district court proceeding is concerned, the whole concept of judicial estoppel is curious to me there, because typically, if you're going to apply judicial estoppel to a party, the findings of that proceeding would be unfavorable to my client. But in this case, it was actually favorable.
I'd like you to focus on the jurisdictional issue.
Which one?
Well, over RKPT, Galasso, and Stasis, because RKPT and Galasso are residents of Ohio, and their principal place of business is in Ohio. And then Stasis, I think, is in Greece.
In Greece.
I can't remember.
Yes.
Where? So, Cyprus, thank you.
Cyprus.
So what evidence do you have that there is jurisdiction?
Sufficient context on the 302 with respect to
Go ahead.
With respect to Mr. Galasso and his firms. Various indications. They build more than $1 million worth of business, transacting business in New York with a New York resident, which was Mr. Poyatis, and also the company CTP, which was situated in New York. In addition to that, they had hundreds, 87 communications that we submitted in the record regarding their work product with the New York local council, who was Tarter, Krinsky, and Smith. There's extensive contact here. The only contact with Ohio is that the property was there. And that was owned by an LLC. An LLC are fundamentally derived by the individuals who owned the LLC, who were the two New York residents, one of which was one of the appellants here.
What business did they transact there? I know that there was contact with the New York Council, but what business did they contact?
Meaning RKPT?
Yes.
Well, it went from 2014 to 2018.
I mean, sufficient to gain long-arm jurisdiction.
Yeah, well, they had over $1 million in revenues. We're assuming those revenues were legitimate and that they were for work conducted with respect to the property, which they were, and they're identified as such in the papers. And it's that extensive contact, and also working with numerous communications that we submitted as part of the record with the New York Council, with New York. So they had a lot of influence, phone calls, letters.
Is that enough, though, or do they need to do something more than just
No, I think that's more than enough, actually.
with the council here?
Yeah, Your Honor, they were billing, the answer is it's more than enough in my estimation.
I understand you keep focusing on, I guess, what would be the substantial revenue part of it, but there are other.
I'm sorry, I didn't hear that last.
You're focusing a lot on what would be the substantial revenue part of getting long-arm jurisdiction, but outside of the revenue that was generated, what other things should we look at?
Okay, very quickly, the revenue was generated with a two New York domiciliaries, the company CTP and Mr. Poyatis, who resided in New York at the time. In addition, in direct response to your question, we listed 87 communications that reflect 4 years of work with the New York Council concerning this particular property in Ohio, with New York Council, with New York domiciliaries. There has been jurisdictional cases that have obtained jurisdiction far less than that contact. I would also ask that with respect to Mr. Stasis, it becomes a little bit a little bit unclear, but still we have jurisdiction over Mr. Stasis. And the reason is because he was deemed to be in control of the company, CTP, that did all of this work, and he had a reasonable expectation that if you're going to commit a fraud in New York, that it would have consequences in this state and in this region. So I think even he...
So what was the fraud that was committed in New York?
I'm sorry, sir.
What was the fraud that was committed in New York?
The fraud was committed was the misrepresentation...
New York.
Yes, the misrepresentations to New York residents, Mr. CTM, the two owners of the LLC, the funding company, who was a New York company as well, saying there's no other potential claim here with respect to this property, when Mr. Galasso actually testified in 2021 in the findings of the court that he was telling courts in Ohio that buyer one had the property, when he's telling my client, no, you had the property. That kind of fraud is not something that should be granted relief from this court. It's an equitable remedy of judicial estoppel and shouldn't be granted relief. So with respect to the personal jurisdiction, there's some other items I also mentioned in my brief, but the major focus is I'm working with a New York domiciliary. I'm getting money from New York, the funding companies in New York. I'm defrauding the people in New York. Two of my attorneys who I'm working with are in New York. Seems to me that's enough to get jurisdiction under 302, Your Honor.
Were they able to have reasonable reliance on the misrepresentations that were
Yes, because there's the argument that was presented with respect to reasonable reliance was that he didn't make the statements direct, the defendants didn't make the statements directly to Mr. Slabakis and CTM, the separate entity. First of all, the proofs on this are that they made the statements direct. CTM and Mr. Poyatis made the statements directly to Slabakis and CTM. With respect to the other individual defendants, they can't hide behind the fact that they're misrepresenting it to other counsel. I cited cases on that as well. You can't say, well, I misrepresented this to your attorney, but I didn't speak to you directly.
But what about the justifiable reliance on that? Wasn't there evidence that...
I got a little nervous.
I determine whether you can continue after the red light. You don't mind. So wasn't there this newspaper article that they said they learned the information from? They had already known at that point that the first property was sold at the time that they were told by the attorneys that, no, the property wasn't sold. Isn't that right?
No.
Okay, so correct me.
It's not right. The sequence of events was that the two contracts were out there. Then this newspaper article came up before the closing.
Before the closing, right.
Before the closing, not before the contract was signed.
Before the closing, right.
So what happened was, at that time, they said to Mr. Samari and Mr. Friedman, representatives of CTM, legal counsel, and Mr. Slabakis representative, that the contract hadn't been, it was a nonsensical article. There was no other contract. They maintained their position that there was no potential claim to this. It's not a reasonable position.
And it wasn't reasonable for them to rely on the newspaper article? That there were these two contracts?
Well, no, I don't think it is, actually. They went to the horse's mouth, and that doesn't absolve the attorney saying, well, the newspaper article's nonsense. Nothing ever happened there. And that was just a couple of days before the closing as well. So they tried to verify it, and they were told no. And in reality, it was, and it destroyed a lot, as we alleged in our papers. But I have 2 minutes to rebuttal. I'll take mine.
Thank you.
Good afternoon, Your Honor. Anthony Doherty, Archer and Griner, on behalf of the respondents, Robertson, Kelly, Patterson, Tucker, Mike Galasso, Cincinnati Terrace Plaza, Royce Puyagis, and Harris Stasis. I think I'm going out of the caption only because you raised the issue of jurisdiction first. So I think it's prudent that I talk to the jurisdiction issue. First of all, CTP is not a New York domiciliary or a New York company. This is an Ohio case. The hotel is in Ohio. The contract is in Ohio. Counsel is in Ohio. There's a selection provision in the contract. Ohio is the proper forum. With respect to general jurisdiction, there's no general jurisdiction over the law firm that's in Ohio.
Let me turn you in a different direction when you bring up the forum selection clause. How does that tie in with what statute of limitations would apply here?
Your Honor, it directly goes to the statute of limitations with respect to 4 years of
Well,
fraud.
isn't the statute of limitations a procedural matter, and aren't procedural matters governed by the law of New York?
Actually, Your Honor, in this particular case, when it says the internal laws of Ohio, the 4-year statute of limitation in Ohio prevails.
But doesn't New York regard statute of limitations as procedural? And if
Yes,
it's
it does, Your
procedural,
Honor.
if it's procedural, we follow the law of New York or the law of the domicile of the person or the entity bringing the action, which in this case I think brings you to New York and Delaware and not Ohio.
I think, Your Honor, first of all, I agree with what you just stated. But New York also takes the position that if there is a conflict of laws between two jurisdictions, New York will pick the jurisdiction that has the shorter of the statute of limitations. And in Ohio, it's 4 years.
You're saying that overrules our usual, are you saying that overrules the general rule in New York that statute of limitations is governed by, is a procedural matter which New York controls?
I don't think it overrules it, Judge. I think it supplements it to the extent that New York will say, New York, when there's a conflict, we have statute of limitations at 6 years. Ohio is 4 years.
But there is no conflict, because if our law, case law has been interpreted, says that when we're dealing with statute of limitations, it is always a procedural issue. There's no conflict. Why do we even need to look to outside of that?
Well, because I think New York takes the position that if someone is foreign shopping, and clearly that's what happened here, this case belongs in Ohio. It doesn't belong here in New York at all.
But we have, the residency of the company is in New York. So it's not, that's where they are. That's where the case is right now in New York. So
But the company
have to
doesn't
look-
reside in New York.
Well,
CTP does not reside in New York.
that may be, but that's not what's in the contract. And there's nothing specified in the contract that says, no, for purposes of procedure, we are changing to New York. Nothing. So, okay.
Well,
if you
I would
think-
disagree, Judge, to the extent that it says all internal laws of Ohio.
That's
It
not-
doesn't exclude laws of Ohio, but it says all internal laws of Ohio apply to this particular provision. And if any other questions, I
Maybe you
rest on my
needed-
briefs.
Maybe that needed to say, including the statute of limitations.
It doesn't exclude statute of limitations.
But that's not specific.
Yes, I agree with you, Judge. To the extent that, moving off the statute of limitations, this is a breach of contract case. It's not a fraud case. The allegation is there's a breach of a particular provision of the contract, and all fraud allegations point to that breach of contract. It's a breach of contract case. There's no fraud, whether it's in New York or Ohio. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Rob Berkson, Abrams, Garfinkel, Margolis Berkson for Tarter, Krinsky, and James Smith. As counsel pointed out, the crux of this claim is breach of contract. It's dressed up as a fraud claim, and it's interesting that counsel started with res judicata. It is a contract case. My clients were the attorneys who represented the seller. They are not parties to the contract.
But if they...
There's no privity with them.
intentionally, if, as is suggested, they intentionally misled one seller or the other, or both sellers, as to the existence of two contracts, it seems to me that that reaches into the area of fraud in addition to breach of contract. So I'm surprised that you just disregard the fraud claims and treat them as not relevant to what's going on here. It seems to me that when one reads the sequence of what happened, fraud is a very large element of it.
Well, Your Honor, the genesis of that is the contract itself and the representation that was made in the contract. My client was not a party to that contract. There are no specific allegations against my client that they made any misrepresentation.
Client is not part of the contract, so there would be duplicative breach of contract. So why can't fraud be an independent cause against your client?
Well, it can be independent if it's based on different facts and it's seeking different damages, but that's not the case here.
Isn't there case law saying that if your client is not a signatory to the contract and it pleads facts that are are different than the breach of contract claim, then the fraud survives.
There are cases that say that, Your Honor, but there are no allegations in this complaint that there are just group pleadings of fraud. There's no specific allegations against my clients.
Let's deal with Mr. Smith. Isn't there an allegation that one of the plaintiffs, I think, I pronounce his name correctly, Skavakis? However you pronounce his name, stated that there was a direct question to the lawyer prior to the closing as to whether or not the veracity of a newspaper argument, as my colleague mentioned, that seemed to question who was the owner.
But that wasn't directed to my client.
There was nothing that, the lawyers did not answer that question in saying that there's no ambiguity and there was no first contract?
I can't.
Isn't that alleged in the pleadings?
There's nothing specific with respect to my clients. I'm not aware of it with respect to any of the other attorneys.
You're not aware of it with respect to any of the attorneys, is that what you just said?
Yes. I mean, there's a reference to there's a reference to the article, but I don't see anything. There's nothing in the complaint that says my client made any statements regarding that article. And that's the problem with these fraud claims. They're not specific.
Is that it?
Excuse me, Your Honor?
Is that it, I said?
Yes, Your Honor.
Okay, thank you very much.
Just very quickly, so I don't lose it. Remember that Mr. Slabakis has an independent claim, and he's not bound by either the res judicata issues or the contract. So he has an independent claim because he went out and mortgaged his property to finance this, and I didn't want to forget that. As far as the statute of limitations is concerned and the contract itself, that's a contract between two parties, a CTM and CTP. Why are these other individuals attempting to get the benefit of that 4-year statute of limitations? They weren't party to the contracts. They were not signatories to the contract. They weren't mentioned in the contract, nothing about that. So I don't think they get the opportunity to do that. When they talk about it's just a contract claim, there's a difference that the court is very well aware of, I'm sure, but let me state it anyway. There's a difference between making an allegation that the duty to perform under the contract is a misrepresentation because they didn't perform, and then versus a misrepresentation of an existing fact, which is there is no potential claim. It is totally unreasonable for anybody to think that there was no potential claim here. In fact, Mr. Galasso actually admitted it to the landlord-tenant court and to buyer number one in separate proceedings when he testified in the district court. I told him that buyer one had the contract when he knew that we had another contract with buyer two.
Your friend that Mr. Smith was not involved at all. He said nothing. There's no allegations of fraud as to Smith.
Look at I don't have the full record with me now, but look at Mr. Slabakis' affidavit, which is entitled to supplement the allegations of the complaint.
What specific allegations did you allege as to Smith?
Smith made the misrepresentation that there was no other claim to this.
So there was some misrepresentation.
Yes.
Were the words specified in the affidavit or the pleading? Is it a general allegation, or is the words
in the pleadings? It was a general allegation, more so, and then it was a little bit more quantified in the affidavit.
What was stated in the affidavit?
The representations, basically what I said. The specific words were that they did not have any other claim. There was no other contract to that, but I don't really recall off the top of my head with respect to that.
But that was in the Slabakis affidavit, you're saying?
That's supplemented with the affidavit as well. Yeah, but you have to understand, they're working together on this, okay? Smith, they're co-counsel on this, together on this, representing to someone else. There's no other contract. It's in black and white that there was. I don't know if there's any specific questions that the court would like me to respond to beyond which we've...
Well, if you were as clear as possible on that last point, I think then that's fine.
Yeah.
Thank you very much.
Okay, thank you
you all. Tartell versus Klein.
Good afternoon, Your Honors. May it please the Court, Michael Gordon, Gordon Law LLP, for plaintiffs' appellants Paul Tartell and Brian Grodman. Contrary to how my adversary would like to reference this case, and contrary to the way in which Justice Engoron described and ruled on this case, this is not about an internal political strife. It's not about internal debates over policy or strategy.
Let's talk about the business judgment rule. How do you overcome the business judgment rule here?
So the business judgment rule, as this court held in a case called Ackerman in 1993, and most recently in December of 2025, and I added that additional citation today, the business judgment rule does not apply on a 3211 motion where there has been no discovery if the allegations in the complaint, in the words of the Ackerman case, suggest bad faith or self-interest, self-dealing, bad action.
Are you talking about the president's consultancy as bad action or something? Or
Oh, it's much more than that.
Okay.
So the specific acts that are alleged in the complaint begin with blocking any sort of oversight, involve using staff to squelch any sort of debate, involve lying to the board about the existence of a compensation committee that doesn't exist in order to justify a rather exorbitant salary.
But when you get to the business judgment rule, isn't there a vote at the end, at some point, in which a major majority of the entire board votes to continue the leadership that's in place? And I know that you've got directors whose independence is placed in question by this litigation, but all of those other board of director members, there's nothing putting in question their independence, and they vote to continue keeping Klein in office.
I understand, and thank you for that question, Your Honor, because it gets to what I believe is a serious mistake that Justice Engoron made, and that is repeated by my adversary. We're not challenging board action. We're not challenging.
But I ask you that question in terms of the business judgment rule.
Right, and the law is that the business judgment rule is applicable to, in the case where single defendants, single directors are being held liable, are being named in the case, we look to the individual defendants and we look to their independence and whether they acted in good faith. This is not like a case where, for example, a condo board member sues the entire board because it does something on behalf of the condominium or the organization. That's not what we're talking about. Here, the question would be whether the particular actions by the defendants warrant them being shielded.
How does that overcome the supermajority of the board, which votes in favor of the people who are currently in office?
Because no vote was taken to ratify or affirm any of the bad acts that are alleged.
But at that point, all of that is in front of the board. The board is aware of all of these allegations.
Well, with respectfully, Your Honor,
maybe not at the specifics of it, but they know that that there've been charges.
And there is absolutely nothing in the record that would support the contention, the notion.
Counsel, isn't it more than that? Besides the election of Klein, there was also the removal of Tartell. I think it was 22 or 23 out of 33 removed Tartell. I think one was as a member, one as the chair, co-chair, I believe. So doesn't that mean that there were some other independent members of the board who are not implicated in the allegations that would provide at least some shield to the business judgment rule?
And this was all after they had then gone back and commenced an investigation into those demands that he had made in the July 17th, 2024.
So to respond to that point first, no, there was no independent investigation. There was all.
So that's in the record, so that's incorrect?
That is incorrect. What the record shows is that in August, months before, weeks before this election, and then, I guess months before the record was completed, back in August, a so-called special litigation committee.
So you're calling it a so-called special, but there is evidence in the record that they did commence this investigation.
And did nothing. There's
Okay.
nothing in the
But
record.
then after that, to get to my colleague's point, Tartell was removed and the president was reelected.
Yes, and
that was a majority of the board in both of those actions.
And that's why this action is not brought against the entire board of the ZOA. It's brought against particular defendants, and it's those particular defendants who are seeking to shield themselves with the business judgment rule, and that is not something that they're entitled to do because they themselves have acted, as the complaint alleges, in bad faith against the interest of the organization. And so again, regardless of the independence of the full board, the business judgment rule is we're only looking at these particular defendants and whether these particular defendants can say the complaint does not suggest wrongdoing on their part. And it doesn't.
On their part, but in furtherance of the business.
Well, the complaint makes it clear that their actions were self-interested against the interests of the organization. The most damning allegation there would be that Mr. Klein was deliberately suppressing, if you can even imagine this, suppressing donations in order to make himself look more important because he wanted to be the bigger fish in this smaller pond.
Mark Kasowitz for respondents. Justice Engeron was completely correct when he found that the actions of the board here have been protected by the business judgment
But
rule.
your adversary seems to suggest that it's not contesting the entire board's position. It's just he's plucking these particular 4 individuals out for their actions, which is not necessarily business judgment.
Yeah, it doesn't work. If he wants, if the plaintiffs here wanted to bring individual actions for something against individual board members, that's fine. But the business judgment rule applies to the conduct of the board. There is a 30, the ZOA's board was 30 plus members, 30 plus members. The supposed not independent members are the ones, are some of the ones who were named in the complaint. Even if these members had acted in some inappropriate way, and there is not a single specific allegation of that. The council just mentioned something about the suppressing of donations as somehow being something that Mort Klein had engaged in and that these other board members somehow had been involved in. There is not a single specific allegation in the complaint of which donations were depressed, of why they were depressed, of how they were depressed. This is, look, the plaintiffs here don't like Mort Klein. They think that he's too old. They think that his time has passed as the person who's run this Zionist Organization of America for the past 30 years. But the board does like him. The entire board does. And this panel was correct in pointing out that two very, very important facts. In July of 2024, the Mr. Tartell and Mr. Grodman engaged in a vicious letter writing campaign through their counsel, making all kinds of generalized allegations of improper dealings by Mort Klein.
And I assume those letters were sent to every member of the board.
Every member of the board, sometimes twice, okay? So these allegations were all out there in July, okay? Later in July, Mr. Tartell was removed by the board as a board member. In September, on September 29th, it was the triennial election of the ZOA. Now, the effort had been made by these two individual board members, these dissatisfied board members, to remove Mr. Klein, to remove Mort Klein. That failed in front of the entire board. And on September 29th, 2024, Mr. Klein was reelected.
Yes.
He was reelected. And not only was he reelected, but neither Mr. Tartell nor Mr. Grodman were reelected. This is exactly the kind of business judgment that Judge Encaron was talking about that applies here. Something about business judgment affecting a small minority of the board, that's the law is exactly opposite. If you're going to show that there is some defect in the exercise of the business judgment rule by a board, you have to show that the majority was somehow unduly influenced, acting in bad faith, and you have to proffer specific allegations of specific misconduct by these individuals in order to preclude the application of the business judgment rule. There's not any of that here. None of it. Instead, you've just heard Mr. Tartell's counsel, Mr. Grodman's counsel say, no, we don't have a problem with the majority. It's just a few people that we're going after. That makes no sense. Thank you, Your Honor.
Thank you.
So, first of all, the business judgment rule does not mean that a derivative action can't be brought against a subset of a board or of any organization, which...
But how do you take into account the fact that the majority of the board reelected the parties that your clients don't like after your clients had ample time to write to and discuss with the other members of the board all of their claims about why they shouldn't reelect Mr. Klein, Mr. Margulis, and so on. So that information, your client's information, was made available to members of the board, and they reelected those people. How do you deal with that?
For two reasons. Number one, because the board was deprived of the very independent investigation that this all started with. My client...
The other members of the board, if they had wanted an independent investigation before having the vote, could certainly have done that.
Well,
but they nonetheless said, we're happy with not having had the investigation. We're ready to vote.
Or they could have been part of the investigation because they did take up a committee to investigate the letter.
So, except that there were three members of this, again, I'm going to use the expression so-called special litigation committee because the record is clear, it never did anything, and the rest of the board never had...
The board wasn't unaware of this, and the board members had an opportunity to be a part of it or question it or do any of the other, but instead they reelected
Well,
the president.
there's nothing in the record that would indicate that any other board member had any opportunity to do that, number one. And
There's nothing that indicates they didn't, and they all were aware.
No, well, again, remember, we're dealing with a 3211 motion. That doesn't change, you don't escape the limits of a motion to dismiss.
We also don't escape that there was an election, and they chose to elect the president and chose not to reelect the other members who had initiated this.
I understand, but that again presumes the very knowledge that the whole point of this lawsuit was this derivative action was intended to elicit, was to alert the board with facts from an independent investigator backed up by a world-renowned investigations firm to show that this is not just a matter of allegations by two former very senior board members. These are facts, and they never had that opportunity. And the law, again, is I believe, is very clear that we do need to focus in on the business judgment rule as it pertains to the individual defendants and not the entire board.
Thank you.
Thank you very much.
Thank you all.
Thank you, judges.
Moy versus Mount Sinai Hospital, and Judge Bahati Pitt Burke is recused from this case.
Good afternoon, Your Honors. May it please
Just a moment.
Oh.
Okay.
Good afternoon. May it please the Court. Brittany Buslato, Ackerman LLP for defendants, appellants, respondents, the Mount Sinai Hospital, Jeff Cohen, and David Grodowski.
So I'm going to just ask, how did you eliminate the questions of fact on reasonable accommodations when plaintiffs submitted evidence that they could have been kept in the same position?
Your Honor, respectfully, the plaintiffs did not submit evidence that they could have been accommodated in their current positions. They submitted unsubstantiated assertions and speculation that they could have been accommodated.
Wasn't there, well, that they could have, I mean, I think there was discussion from the very people who were the leadership that they could have used the mask, what was it called? The larger masks that were left for nurses.
Peppers?
I'm sorry?
Peppers?
Yes, that there were 600 of or something like this, or whatever the number was. It was more than 6. And so they didn't want to use it except for the nurses. They said that there were areas that they could wait if they had aerated it or done whatever, they could wait until that was done, or they could wait 30 minutes until a person was out of the room, or they could have been sent to places where there was no issue with the patient. So those were other accommodations that may have been possible.
They were, except they were not possible. With respect to
Why not?
Peppers, there were 100 available throughout the entire Mount Sinai Hospital. The hoods are single use, although like an N95 mask, there are circumstances where they can be disinfected up until a certain point and reused. So it's not 100 that can be used thousands of times. And then more importantly, they discussed the use of Peppers, the environmental health leadership, and they are not appropriate for these types of employees. A nurse can wear a Pepper in a COVID unit and work his or her entire shift while wearing that Pepper.
So what about waiting 30 minutes until a person is out of the room, or aerating, or whatever that was, or leaving them in the units where there wouldn't be any issue? Because we were talking about, I think, 6 people.
6 people, correct, Your Honor. With respect to waiting, it just, unfortunately, in a hospital situation, you can't always wait 30 to 45 minutes before cleaning a room. There were no...
I thought the relevant period was 30 minutes. You just increased it by 50%.
Well, I think it was 30, when David Grodowski, the head of building services, was deposed, he said it was 30 to 45 minutes. So that's in the record. But regardless, let's say it's 30 minutes.
This is occurring, is it not, during the height of the COVID crisis?
Correct, Your Honor, and that's what I think what was missed by the court below. This isn't your average case of one employee seeking an accommodation under normal circumstances. These are employees working in a hospital at the height of the COVID-19 pandemic, in the COVID-19 epicenter of the United States, among critically ill patients, and they wanted to work without N95 masks. And there were no units that were non-COVID units.
How many people, since we're talking about 6 people, how many people were in the unit? How many of these employees were there who were in this, whatever the maintenance unit were, the EV unit?
The entire department, there were 500-600 employees, but the problem is...
For the hospital?
Through the entire hospital, correct.
So why would 6 have been an issue?
6 was an issue because you would like to think that all COVID patients were maintained in this unit and that unit, but that's not true. And a person comes into labor and delivery, they don't come in because they have COVID. They come in because they're delivering a baby, they take the test, you find out they're COVID positive. So there's no way, even with 6 employees, to limit them to areas that do not have COVID-19 patients, because in the winter of 2021, there are no areas. A COVID patient could be found, a COVID positive patient rather, could be found in any unit.
What was the percentage of COVID patients at the hospital at that time?
At that time, Dr. Bernard Gimenez, the head of infectious diseases, estimates they're about 50% because they were in the Mount Sinai was in the
Spread
middle
all
of the
over the
surge.
hospital.
Spread all over the hospital. Correct. There was no way to contain these patients. So they would
So
come in
where
for
there
an
was no basement or other area that the EVs worked in, that these 6 people could have been in or juggled around a bit, they had to be on the floors where, or there were no floors where there weren't patients, that there would have been EV workers.
Correct, mostly. And then I think perhaps there were certain areas, but the problem is because this was the COVID-19 pandemic and the height of it, many employees were calling out sick, and even under normal circumstances, employees were moved around all the time in building services. You weren't just assigned to one floor, right? Something would come up and they'd have to be nimble with staffing because this is a hospital and patient safety and patient care comes first.
Do you want to spend a few minutes on accommodations?
I think I answered. I believe, as just discussed, they couldn't be accommodated in the unit. They were offered reasonable accommodations of a transfer position, same pay, union benefits. 2 of them rejected it, but 1, importantly, accepted it.
And Moy actually just left the job without any further contact. He just stopped showing up at one point.
Correct. He worked in the position for a couple of months, and then he abandoned
Wasn't it
his
5
job.
months?
I'm sorry?
Was it up as much as 5 months that he was in a position?
I think something like that. Thank you.
May it please the court, my name is Brian Arbite for the plaintiffs, respondents, appellants.
I wanted to ask you, is there an analogy between this case which you brought and the situation which we faced in other contexts with vaccinations for COVID, in which the city of New York, for instance, adopted a policy that employees must be vaccinated for COVID. If they weren't vaccinated for COVID, they lost their job. Now, there were possibilities of religious accommodations, but we've seen many of those cases, and I don't think that I've seen one where the city has been held to take back people who were terminated because they didn't go for the vaccination. Is there a similarity here? I mean, this is the policy. The city, the police department, the teachers, all of those employees who had civil service protection were dismissed because they didn't go for the vaccination. Isn't there a similarity here?
So there's not a similarity because this is not about our clients' inability to wear PPE. They wore PPE. They wore surgical masks. That was the
They didn't wear the mask which the medical directors of the hospital felt was necessary in order to protect them and to protect patients.
But it was only necessary in those limited circumstances. We're following the Mount Sinai PPE policy guide for building services. Only if you're having direct interaction with COVID
But if they had
patients.
to go into a room where there had been a COVID patient and the room needed to be cleaned, and that was their job, they wouldn't be able to do it right away.
But that's not their job. Here we had Moy, who was cleaning the
They were
corridors.
not, part of their duties was not to go into a room and clean the room after a patient who had had COVID had been in the room?
No, that was not part of their normal duty.
What was their normal routine?
So,
and where was it
Mr.
in relation
Moy-
to the patients?
Mr. Moy was in the emergency room in the corridors, outside patient rooms, so he wouldn't go inside the patient rooms. Mr. Shaw was in the labor and delivery building, and he worked on the floor care, so he's not going to patient rooms. He also worked with somebody else as a team that could
So
have
if
gone.
you were on the floor, but you didn't go into the room, you did not have to have the mask on?
You didn't need an N95 mask. You needed PPE. They wore surgical masks. That was the common.
So if the nurse's station is there and there's the corridor in between the nurse's station and the rooms, they could be in that corridor without PPE, but if they had to go into the room,
correct,
I mean, without an N95, if they had to go into the room, then they needed it.
Yes, the
But
rooms.
what happens if they were staffed on that floor and then they were asked to go into a room? What were they supposed to do then?
There's, again, 700 employees that can go into an active COVID patient.
How many people work on a floor at the same time?
I believe 2 at least, but there's.
So you're saying an alternative person could have gone into the rooms and that person could have focused on the.
Correct.
corridors.
And these patient rooms, there's
Isn't
zero
it,
pressure rooms.
isn't it true, it's not only safety to the patient, it's how about safety to your clients? They have to ensure that the workers are safe from COVID, and even on the floors, and certain places where there's COVID patients, I thought it was a dual approach. I thought it was safety to the patients and safety to themselves.
The safety is the PPE that they are wearing.
I
They
didn't
work
see
through the height
anything
of-
that required, at least in the discussion, that required them to have the N95 as safety to themselves unless they were going into the rooms where there were COVID patients, so that they would have been able to be in a corridor or someplace where a COVID patient was not.
Correct, and that's why there's evidence of the records showing that literally this was the only management team enforcing this N95 testing. Even the doctors, nurses, PCA that have direct contact with patients, they're not being required to shave to wear an N95 mask.
I mean, my recollection of the time is that anyone in a hospital setting was wearing an N95. If you wanted protection from, the thinking then was that if you wanted protection from COVID, you needed to be wearing an N95.
Well, I don't know that that's part of this record, but, and
But there's also evidence, there's discussions
I mean,
that
it's something we all lived through, thank goodness, but the surgical masks were not looked upon. It was just a matter of common knowledge that you didn't get the protection you needed, let alone in a hospital, from wearing a surgical mask.
But if N95s were required for everybody in the hospital, I think that would be a different story. Their own policy only requires them in limited.
So why did, from your perspective, why did the hospital want these employees to be wearing the N95?
Because they didn't want to make an exception to the entire building services department. That was the discussion. Do we require everybody to shave? No, we can't exempt everybody. We can't not enforce this. There was never a
Well,
individual assessment.
is that not a valid concern, that if you need, you can't start having this one does and this one doesn't? I mean, soon you'll have no one wearing it, because obviously wearing a surgical mask was a lot more comfortable than wearing an N95.
But this is about respecting religious practices. And
how many people made these requests? How many people?
I believe only 5. One was a medical reason, so there's only 5 religious.
So 6 people out of all of these, how many?
The testimony is over 700.
And how many would have been in that particular area? Or, I mean, on a day when people came in, it wasn't, 600 or...
I'm sure it's spread out over, but I'm sure it is hundreds of employees. And that's just within the Mount Sinai Hospital. There's the Mount Sinai Health System.
Well, I'm only asking about the Mount Sinai Hospital because that's where these people were assigned.
But they could be moved to another hospital or another location. And that's part of the labor relations was for Mount Sinai Health System. They said they looked in other locations for other jobs. They could have moved them to an office building, 11 floors of office building, where they could have worked away from kosher paste. They could have stayed in their own locations where they worked during the height of the pandemic. There was no individual assessment here, no written determination for cooperative dialogue. And I see I've run out of time.
I have a quick question. I'm curious whether it's any part of your analysis and reasoning in support of your argument that some of the higher-ups at the hospital used expressions like, these people are using the religion card, or other things like that.
Yeah, I mean, that's part of the analysis. I mean, I think that's why the discrimination claims were improperly dismissed. But that's also why I think there was a failure of a cooperative dialogue in this case, and there was not a reasonable accommodation in the person's position. They thought that this was a choice rather than a religious mandate, which that's not what the analysis is. If there's a religious belief, they need to respect it, regardless of whether it is a choice or a mandate. And there is evidence to show that it is a mandate.
We have this religious belief coming up repeatedly in the context of vaccination. And I'm unaware of a single case in which the court has done anything to uphold the claims that the religious beliefs of people who didn't want to take the vaccination were not respected.
Were the vaccinations the same as a mask? I mean, I'm assuming, although I don't know that this has anything to do in the record, although I'm sure, I mean, I understand we're comparing a case, but vaccines, I'm assuming that these people had vaccines.
I mean, they were starting to roll out. I don't remember at the time. I think they were starting.
There was no vaccine at that point yet.
No vaccines at that point yet.
I know it was starting. They were coming up with.
But so then that wasn't even an option. We're talking about N95 masks where these people would have been able to be put someplace else.
Yeah, so they don't need N95 mask or PAPRs. You don't need an N95 mask or PAPR if you just work in a corridor, a public area, an office building. You go in, clean patient rooms that have been vacated for 30 minutes. You clean a patient room that 70% of the hospital at the time is non-COVID patients. They've been tested. They know they don't have COVID. You can go in there, you can clean that room without needing an N95 mask. That is their policy. And Dr. Gimenez testified that aligned with what their practice was. We're not
And there was
asking.
a reasonable accommodation is your position. Anyway, thank you. Any other questions? Thank you.
Thank you. Just a few discrepancies I would like to address. It's not true that these plaintiffs did not clean patient rooms. Plaintiff Ronald Moy testified that although he mainly cleaned corridors, he also cleaned patient rooms at times.
But the point is not whether he did clean the patient rooms, but whether or not, I mean, if there are two people working on the floor, you wouldn't put both people who were Muslim and had beards and had not had the opportunity to do the fit test. You presumably could put one person who was and one person who wasn't. So if a room came up, you would have the person who wore the mask go in the room.
Correct. If there were only one room, what if they were assigned? I think Carl Baxter, the operations manager, testified quite clearly to it in the record on 211. If there's one room that works, what if they go to a unit's labor and delivery? You can't expect it. What if half the patients, the pregnant patients, are COVID positive? They don't know that until they get there. You have one housekeeper who can't clean.
The question is whether they're getting out of the room, not going into the room at the same time.
No, there's 6 who just vacated the rooms, right? So now you have half the rooms on that corridor were vacated by COVID-19
But you need to
patients.
you may need to put someone else in the room on an emergency basis.
Right, and then so now you only have one
So then
person.
you
who
have
can
one
clean.
person cleaning that room, and you have 6 people who are ready to go back into that room. Presumably, if you only had one person, takes them 30 minutes, the rooms would be clean. Anybody could go in to clean the rooms after that.
Well, 6 is maybe not the best example, but what if 8 of 10, and then you have one person who's cleaning 8 rooms, the person who can't wear the mask is cleaning 2 rooms and is waiting around, and now there are patients waiting in triage.
I think you have to get somebody else because the rooms would be past 30 minutes and one person can only clean one room. So, I mean, you're giving me a scenario where if somebody's in that one room or 2 people are in 2 rooms, still the other rooms are sitting there and they'll probably have to be there for 30 minutes. Meanwhile, these people can get out and go back in the rooms. I think that, these kind of hypotheticals are good for impact, but I don't know about reality because by the time they're finished, the other room would have been open for 30 minutes and there wouldn't be a problem with
Well,
them.
with respect, all I would say is, we have our opinions. We're not medical professionals, and I think people at the head of infectious diseases, among other people, looked at this.
Why
and they
was it
said
in other
wasn't
hospitals
possible.
they didn't have this issue?
I'm sorry?
Did they have this issue in all hospitals?
In every Mount Sinai hospital?
No. In other, not Mount Sinai, other hospitals, there was indications that it was not happening in other hospitals.
I don't think there's anything in the record to show one way or another what was happening at other hospitals with respect to COVID-19 and N95 masks, but regardless, as what Justice Lattin said was that there was a legitimate reason to have this policy in place.
Thank you. Thank you both. Owens versus New Empire Corp.
Good afternoon, Your Honors. John Lichtenstein for the Appellate U.S. Weather Seal Windows and Doors. Your Honors, this case contains the same exact facts as this court's decision in Board of Managers of the A Building, which was decided in 2014. Justice Friedman, you may have the excuse for having some deja vu because you were on the panel on that decision. It's essentially identical to the instant case, where this court granted or affirmed the grant of a motion to dismiss pursuant to 3211A7. It involved a defendant movement that was the manufacturer and installer of windows, in which the condominium plaintiff sued. There was no privity between them. And this court applied the Powell versus HIS exceptions. First, it indicated that the general rule is that there's no tort duty between non-contracting parties.
That just brings us to the Espinal situation.
That's right. So you have 3 exceptions. Only one, the first exception, is applicable to this case. And that's where a contractor creates an unreasonable risk of harm to others. And in Powell, that was a contractor that opened up a hole in a sidewalk, creating an unreasonable risk of harm to people walking by. That type of situation has absolutely no applicability
Well,
to
in
the situation.
the Caritas case, Caritas versus Ferraro, it was a case where there was a water leak and the water was coming down. This is a case where over time the water is coming in and it's damaged the wall and it's damaging the floor. So the question is whether or not it falls into that category under Espinal.
Yes, Your Honor, that's a different case. And the reason that's a different case is if you have an apartment and there's a contractor above you, and because of what they're doing above you, they cause your ceiling to cave in, or they cause a flood that comes down. They've directly injured you. Everybody, every contractor has a duty not to injure or cause property
What they're
damage
saying is
or
that this
personal.
contractor put the windows in wrong, and as a result of it, the sash is not right, and water constantly comes in, and the water has now damaged, whether it comes from somebody who's done something wrong above, or because they've done it in the window, that's what's happening here.
Subtle difference, though, okay? In our situation, my client installed the windows to a building that none of the plaintiffs had purchased yet. They came in afterwards and bought their apartments. This wasn't the situation where...
So what does that mean?
But that's exactly the kind of situation that Espinal applies to. People who are not parties to a contract, but who are adversely affected by the conduct of the person who was a party to the contract.
Well, if that was the case, that would be an exception that would swallow the entire rule. Anytime you had any damage whatsoever, you could sue anybody who you claimed had
You couldn't,
something to
because
do with
most
that
of the
damage.
people have contracts with you. I mean, in most of these instances, there are contracts with people.
So your position is that you install the windows in a building, and regardless of what happens with those windows later, because they were already installed before people moved in, there's no connection there.
What they have is they have a claim, breach of contract claim against the sponsor and the developer. They don't have a claim against every single material man, vendor, contractor, all down the line, who they were not in privity with. This is the exact same case as this court's decision in Board of Managers of the A building. It's the exact same case. In fact, it's just been cited by another trial court in February of 2026. It was cited in December of 2025 in the Carroll case versus 1228. This is pretty bedrock law that the general rule is there is no tort duty between non-contracting parties unless you have an exception. And this first exception, first of all, the Powell exceptions only apply to personal injury cases, okay, unless there's been a direct, unless the contractor has come in and as a result of their negligence caused damages to you or your property. In this complaint, there is actually no plea, there's no claim that there was any damage. All they're claiming was that air is getting in through the windows.
But they specifically allege property damage to the drywall and hardwood floors.
That was in an affirmation that was submitted. That's not in the complaint. The complaint literally contains no allegation of any property damage whatsoever. In my reply, I went through it. It basically says that the windows were leaking. They were uncomfortable. They didn't seek to amend their complaint. They're alleging that they were cold. They were alleging that the corridors were cold, the apartments were cold.
You have some rebuttal.
Thank you.
Good afternoon. May it please the court, Bradley, Polina, Bergstein, Flynn, Knowlton, and Polina, PLLC for the respondents. There are two.
Counsel, is it listed, is it in the complaint that there's water damage to the drywalls or any damage to the drywalls and the hardwood floors or whatever the floors are?
Your Honor, the order of Justice Adams that's on appeal was a denial of a motion to dismiss under 3211A7. When we received that motion, we submitted an affirmation along with our opposition, which we're permitted to do under this court's case law. You are unquestionably permitted to amplify, supplement, expand upon the allegations in the complaint through a factual affidavit or an affirmation, which we did. That was the affirmation of John Owens, and it's in the record. The allegations of
And that
property.
says that the water was coming in, not just air, but that water was coming in and it was damaging the drywall and the floor?
It says all of those things, Judge. And property damage cases fall within the Espinal exceptions. Justice Adams, this issue was raised to her at oral argument. The transcript is in the record. She recognized that. She said, I know it's a property damage case, and she denied the motion to dismiss. I do want to back up for a minute and bring us to sort of what I think is the first issue here, which is this general rule that my colleague relies on heavily is not applicable here. The court could not have granted a motion on the basis of that general rule without finding a fact. That fact being that the parties were non-contracting. You can't do that in a 3211A7 motion. It would have been improper to do so under decades of case law. What Weather Seal asked the court to do and is asking the court to do here is impose a pleading burden that didn't exist. There's really no contention that we plead the elements of a cause of action for negligence. What Weather Seal appears to be arguing is that we were subject to some heightened pleading standard. I read the cases they cited. None of the cases say that. We brought this up in our...
Counsel, are we talking about the same posture in Board of Managers of a summary judgment motion? Here we have a 3211 motion. Is there a distinction?
Of course there's a distinction. Our pleading burden, New York's a notice pleading state. You've got to plead the elements of the cause of action. We did that, and there really isn't an argument that we didn't.
Did you plead that the first exception of Espinal, that Weather Seal was the instrument of harm causing the allegations we just mentioned, that my colleague just mentioned?
Through the affirmation of John Owens, we did, Your Honor. It's quite clear reading the allegations of the complaint and the allegation and the statements in Mr. Owens' affirmation that Weather Seal, as the manufacturer, supplier, and/or installer of the windows.
So case law talks about the affirmation supplementing the pleadings, and that's permissible on the 3211 motion. Is that the case?
We supplied additional facts. What the case law says is that if you're faced with a motion to dismiss, you are permitted to supplement your factual pleading to oppose that motion to dismiss, and that's precisely what we did.
But does that, in supplementing, do you have to somehow amplify what's already there in the pleading? And I'm just to follow up on that, where inside the pleading do you talk about the Weather Seal and their allegations? If you could just point me to that.
Sure. In the pleading, it's in the complaint. It's at there are numerous places in the complaint where we make detailed allegations about Weather Seal. It's on page 51 of the record. That's paragraphs 109 through 119 of the complaint. Again, on page 72 of the record. That's paragraphs 243 through 248. But I do want to close the loop on one point, which is what my colleague here is asking the court to impose is a burden to plead facts beyond the burden that is encompassed within this court's case law. We pleaded the elements of a cause of action for negligence. We didn't have to plead facts to take us within or inside of various exceptions. The cases that they rely on, the A building case, those are summary judgment cases. The burden on the plaintiff on a non-moving party.
A prior decision handed down on February 4th, in which three of us sat, Owens versus New Empire Corp. What's the impact of that on this case?
There, one of the parties, it's an appeal that arises out of the same underlying action. One of the parties, Continental Building Management, also sought dismissal from the case on the basis of an alleged lack of a contractual relationship. It wasn't a negligence claim, but I think that the principle applies perfectly well here, which is if you are seeking dismissal under 3211A7, and the basis for that dismissal motion is that there needs to be a contractual relationship, but there isn't one, you need to show the court, at a very minimum, you need to show Supreme Court what is the contract that governs this very issue. And what this court said in affirming the denial of Continental's motion was, well, Continental says there's no contractual relationship, but they don't show us the contract on this issue, which could say a number of things. It could, to be more specific, provide that the unit owners are third-party beneficiaries of whatever contract existed on that subject area, and I think that that principle can be fairly imported here as well.
Did Weather Seal actually install the windows, or they provided them?
What the complaint alleges is that this was a complaint that was pleaded before any discovery was done. It was a 3211 motion. We pleaded that they manufactured, supplied, and or installed. I don't think it's disputed, and I think it's critical that it's not disputed that they installed them. If there are further questions, I'd be happy to rest on my brief.
Thank you.
So counsel, inside, I think it's what, the 11th cause of action, they do make allegations, and in addition to the paragraphs that your adversary pointed out, 110 through 114, I think, or something like that. But it goes on to mention water leaks and air leaks inside the particular unit. Are you saying that that's not enough at the pleading stage?
This is what the complaint says, and it doesn't indicate, well, first of all, the complaint is 263 paragraphs. Only one of the causes of action is against U.S. Weather Seal. It does talk about—
Is that not enough?
It talks about a huge flood that happened on the concourse and the first floor levels. It doesn't have anything to do with the windows. It doesn't allege it has—
I'm looking at it right now, and it does talk about the windows. And yes, it is, but I think if you go to paragraph 246 and 247, it does talk about the windows and U.S. Weather Seal and the leaks inside the apartments.
What more needs to be said in a complaint at this stage than that?
247 says—
Counsel, I asked you a question.
I'm sorry, Your Honor?
What more needs to be said in the complaint at this stage other than that?
Well, before I sit down, I would just say that regardless of what the complaint alleges, the case is identical to the Board of Managers of Building A. That was a motion to dismiss, not a motion for summary judgment, which I'm correcting my colleague here. It's exactly the same case. That case alleged water infiltration and air infiltration. The way they tried to distinguish that case in their opposition was, well, there's perhaps more water damage here. And the amount of water damage or the amount of air infiltration really has nothing to do with the principle of law, which this court has espoused in that case, which has stood for 12 years, and which other courts are citing to.
I thought you said Board of Managers was not a summary judgment motion?
It was a 3211.
No, it was a 3212. I'll read it to you.
121 AD 3rd, 432.
Order Supreme Court for summary judgment dismissing the complaint. That's what I'm reading. I have it in front of me.
That's 121 AD 3rd?
Yes.
432?
Yes, I just read it.
Oh.
Anyway, thank you. Your time is up. Thank you both. People versus Anzar Thompson.
Good afternoon, Your Honors. Amy Donner for Anzar Thompson. Officer Velsor, who's the officer who conducted the frisk, he pulled Anzar Thompson, my client, out of his car and effectively strip searched him on the street, based solely on an uncorroborated anonymous tip about a, quote, dispute involving a man with a gun.
I'm a little troubled by the use of the word strip search. As I understood the allegations, it's that he was patted down and near your client's crotch, the officer felt something that felt like a gun. I don't think that's the equivalent, and then inquired further, and then pursued it further. I don't think that's the equivalent of a strip search, do you?
Exactly, Your Honor. I mean, it's not the definition, but I'm just saying that he did all this. I'm
Okay,
not
so
saying that it's
I'd
not,
like
but
to
I'm
ask-
saying that- I mean, but it was like, right, he patted him all over, including down there, and where it was found was like.
Counsel, I think that the problem that you're going to run into, if you're going to use terms that don't apply to the case, which have different connotations in the realm of criminal procedure, you're going to run into problems. So maybe you should just stick to what the facts are right here.
Okay, I'm sorry I used that word, Your Honor, but what I'm just trying to say is
So
that.
also, did what they heard was that Jose or Luis, I know he used both names, that the person who had the gun had pointed a gun at him? Was that part of what he reported to?
No, Your Honor, and all that Officer Belthor knew, and that's undisputed, was what was in the radio run. He did not speak to the person. All he knew was.
Well, he knew that there was a dispute with a gun, so you have a detailed description of a person who gave a name and a telephone number and who was able to be called back, reporting a dispute with a gun. Tennessee, and gave a description of the person as a black man with braids, a gray hoodie, in a car with Tennessee license plate. So you were about to say something about the dispute with a gun, I think, perhaps?
Yes, thank you, Your Honor, yes. All he said was that there was a dispute with a man with a gun. He did
A
not
dispute
say
with a
that he
man?
saw the gun.
Okay, well, a dispute with a man with a gun, and then they went and they found the exact description. I think there was a question about, was that information sufficient? I don't know that you have to ask, did you actually see the gun? If somebody says they have a dispute, that sounds like an altercation, something where one is challenged or where there's some concern between them, and there was a gun. That's what the police know. I don't know that they have to know that they saw a gun, but why wasn't that enough where the person was able to be contacted, and it was a very specific, I mean, like a Tennessee license plate is not something you go outside and look around and there's a Tennessee license plate. So that's pretty specific. And then when they went to the car with the Tennessee license plate, that was where they were told it would be in the area. They found a person meeting the description.
Because I don't,
Yeah.
Your Honor,
Go ahead.
because the thing is that the law is basically guarding against the malevolent tipster. Yes, he was out to get somebody. Yes, the caller wanted the police to pick up this person, but he didn't say he saw the gun. He didn't say it was even taken out. And the most important thing is that there's no indication that he had personal knowledge. He didn't say he had the dispute with a man with a gun. He just said he's reporting a dispute with a man with a gun.
So, I mean, a
We can't
neighbor,
infer it.
if a neighbor sees two people
We don't-
arguing, I'm not saying this was the case, but one could call that in and say, there's a man, there was a dispute with a gun, a man, it's the same thing. So whether he was in the dispute or he called to say somebody else was in the dispute, the question was whether or not there was a sufficient basis for reasonable suspicion here for them to be able to go and question him, take him out of the car, and pat him down.
Well, Your Honor, the thing is that in terms of the actual dispute, the big thing in Leighton R that was key to the court's decision is that there was clearly personal knowledge there, because it was the person said the caller.
In Leighton R, what the Court of Appeals ultimately found is that when we're looking at these cases, we have to look at the totality of the circumstances. That's what we're talking about here. And so the totality of the circumstances really points in the direction of this was a valid stop.
All you have, Your Honor, I don't want to cut
A level 3, a valid level 3 stop.
is that all we have is that you have a lot of details about the person, but not about the caller. And also,
The caller provided his phone number and his name.
that's all we have, which is exactly
It was
all they
enough to
had.
call him back.
But
And he answered the phone when he was,
But all we have to go by what the Officer Velso or the frisking officer know. The law is clear on that, and all he knew was dispute with man with gun. Not that the man was shot with a gun. He could have been observing this. He didn't necessarily. So there's nothing, and there's also much less contemporaneity than in Leighton R2. This is several blocks away. This is 6 minutes from the time of the radio run versus 1 minute in Leighton R. And this was just a few minutes after the 911 call is a few minutes after the incident is usually when the 911 call is sent out by the dispatch. So you don't have that. This is basically Leighton R. It's the same situation as Leighton R. in terms of caller's first name, and they analyze it as an anonymous call. It's certainly very different than Herald, where they had a lot of information about the caller.
thank you. I think we understand the point, and you'll have some rebuttal.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Nathan Morganti on behalf of the people. When the 911 caller gave his name and a callback number, he became an identified citizen informant and thus presumptively reliable. And I don't even think we need to reach the issue of the totality of the circumstances here because we do have an identified informant. We have 3 pieces of information that gave us that identification. One is the first name, admittedly a partial name by itself.
And that name changed, right, when they called back the phone number?
Your Honor, you are correct that that name changed, but like my adversary said, that happened.
Vis-a-vis the arrest, when did that name change take place?
The name change took place after the arrest, Your Honor. So I don't think that we can take a look at what Officer Velsor knew, that the name would change in the future, and apply that to the situation, the same as we are not relying on the callback actually being completed. I think the second important piece of information there is that the caller affirmatively gave a callback number as opposed to relying on the 911 system. And then the third piece of information is the use of the 911 system itself. As the Supreme Court said in Navarrete, that is an indicator of reliability.
You say if someone says to you, well, but it's not necessarily his phone. I mean, giving a phone number is very significant. Because if it's that person's phone, you can get to the person. But couldn't it be what we call it a burner phone or something that you couldn't find who it was?
Your Honor, I think that's true, but I don't think that that is, obviously that's not what happened here, which we know after the fact. And I think that, well, that is possible. At that point, we would have to say
It's not enough in weighing this to require suppression.
Exactly, Your Honor. And that could happen in any situation. It would effectively make any 911 call anonymous if we were to assume that a burner phone was used there.
So is it your position that we don't even need to use Leighton R's totality of the circumstances standard? What should we be using?
I think that we should, this court should find the caller is not anonymous and therefore
I didn't
presumptively
understand what you
reliable.
just said.
Oh, excuse me, Your Honor, sorry. This court should find that the caller is not anonymous and therefore presumptively reliable, and then we don't even need to get to this anonymous tipster Leighton R standard. But that being said, even if this court were to find that the caller was not anonymous, I think that Leighton R now shows why, for the reasons that this court has already identified, that we have this incredibly strong contemporaneous observation by the police, the incredibly detailed description, the fact that this took place is...
I don't know if it's incredibly detailed. I don't think that a black man with braids and a gray hoodie is detailed, but I think it's sort of a needle in a haystack to find a Tennessee license plate in that general area.
I think that's true, Your Honor, and I think that should also be combined with the time this occurred at 6 in the morning, so there were... we can take the inference that there were fewer people on the street at that time.
And counsel also suggested that the 6-minute span in time was long.
I would dispute that the 6-minute span in time is long, and I would also dispute that that was from when the radio run came out. I believe, if Your Honors looked at the record, I believe it was on page 51 of the record, if I'm not mistaken, that Officer Velsor makes clear that it is 6 minutes between the 911 call and when he first identifies the car on the street. Regardless, even if that's not true, that would only be another minute or two impliedly, and at that point, we're within 10 minutes. And we're only a few blocks away. And I know that there was a little bit of a dispute about exactly how close this took place to the address the 911 caller gave, which of course would be another identifying piece of information, making him not anonymous. But I think that that closeness in time and space goes towards the totality of the circumstances. If your honors have no further questions, we would ask that you affirm. Thank you.
Several things, Your Honor.
You
Your
know,
Honor, sorry.
even if you don't accept that this is an identified complainant, it's certainly also not an anonymous complainant, because you have the ability, and they, in fact, the police succeed in contacting him.
Well, Your Honor, all we have is a phone number, which, as Your Honor pointed out, could have been it's very different. Could have been a burner phone. It's very different than in Herald R, where they.
But this is not. But this is not. This is not your typical anonymous tip.
Well,
I mean, it's
exactly
an
the same
even
situation
from
as
your
Ted and Lane.
perspective. Even from your perspective, it's an anonymous tip plus.
It's exactly the same situation as Leighton R, where the Court of Appeals analyzed it as an anonymous tip. And
This was just somebody calling, gave a name, had a number, but the number was able to be called back. You've said everything
it wasn't
about.
by this officer. We can only go by what I don't mean to interrupt your.
It was another officer, his partner.
But he did not know. It wasn't his partner. It was another car, an officer, and it was undisputed that the frisking officer did not know that the other officer had called back. So from all he knew was if there was a call. That's it. And
But even assuming it was anonymous, there was still. Exactly.
First name. And a first name, Louis, which is, a lot of New Yorkers have the name Louis.
Okay, I don't think that's a basis as whether it's not anonymous.
But it's the same situation as Leighton R, which was Brian, and that was analyzed as anonymous, and it's not from a particular apartment. And it's very bare bones as to the crime, so there's a real risk of the malevolent tipster. And it's also, between the incident and the 911 call is usually some time, and this is a few blocks away from the reported location. There's basically this, yes, he's out to get somebody with a Tennessee license plate with this description. It doesn't mean that there's anything linking my client to that. To immediately take him out of the car when he could have watched him, he could have asked questions, he could have done other things. My client could have left, then the officer could have followed.
I think we've already, there's discussion as to the totality of the circumstances leading to still there's reasonable suspicion to have been able to go into the car.
I'm sorry, Your Honor.
I said that there was still, given the totality of the circumstances, reasonable suspicion for the officer to have been able to do what he did.
Reasonable suspicion requires particularized as to the defendant. And here, that's not the situation. All you have is something where you don't have personal knowledge like you did in Leighton R.
I think we have your argument.
Okay,
Thank you
Your
very
Honors.
much.
So if the court has no further questions, then we respectfully request that the motion to suppress be granted and all the fruits, everything suppressed in the indictment.
Thank you.
Thank you.
Thank you very much. Seymour versus Hovnanian? Hovnanian, sorry, I didn't have my glasses on yet.
Thank you, Your Honor. Nilo Marachu of Lendine PLLC on behalf of plaintiff appellates. So as the court's aware, there are 3 different orders before the court, and I would like to start with the 2 easier orders, those being the orders concerning the new counterclaim that was added. And so first of all, the motion to amend shouldn't have been granted for the clear reason that no damages have been alleged at all. If you look at what they say in their counterclaim, and this is at page 51 of the record, they say, of the first record, they say at paragraph 71, if and to the extent that defendants pay for work that plaintiffs identify or claim as within the scope of the July 10, 2020 order, but which is not properly within the scope of the order, or which is duplicative, plaintiffs will have caused defendants to incur damages. And then in paragraph 2, they say the exact same thing about their next set of damages. If and
Counsel, can I interrupt you for a second? Why is it so not established when we know that you yourself had amended to go from 514,000 to more than 9 million. So why isn't that?
Your Honor, because the counterclaim has nothing to do with that. The counterclaim has nothing
directly-
to do with the underlying demand for damages.
Counsel, so what I read of it, it's directly related to your increase, that as a result of the 4-year delay, there was an increase from 514,000 to the 9 million, and parts of it were due to your delay, and that's what the basis of the counterclaim is.
That's not correct, Your Honor.
Well, what is correct?
There's a separate issue, which is that there is an order, a specific performance order to clean up and to repair the lead contamination in the property.
You're talking about the liquidated damages, I'm sorry, the licensing agreement where it said that they were going to clean up whatever the soft items are. But what my colleagues is just saying is that it was 4 years before, and it was $500,000. It was expected that this was going to be done in a more timely, prompt, time period. And now they're saying that it's $9 million.
Your Honors are looking at the wrong numbers completely.
Okay, what numbers are they?
Look at page 51 of the record in their amendment.
Tell me the numbers, please.
The first number that was given is $78,723, and the second number that's given is $121,890.
So where does the $500,000 versus $9 million come from?
Thing to reconstruct the building. That is a completely different thing that has nothing to do with this counterclaim. Right? If you look at paragraphs 67 and 69 of their amended complaint, it's an increase of approximately, if you'll forgive my mathematics, it's less than $50,000, maybe $45,000.
So counsel, my point was not necessarily the numbers. My point was that the 4-year delay increased the amount of the soft contents. That's what I was trying to, I didn't have the numbers in front of me, I apologize, we have a lot of cases, so I may have gotten the wrong numbers, but that was not the focus of my question. My question was simply if the reason that they wanted the counterclaim was because of the delay, whatever the amount of money is.
Well,
Excuse me, and that's exactly what the paragraphs that you cite to say, that they explicitly say that the reason for the increase is that the delay caused the same work to cost 50% more.
But they haven't done the work yet, Your Honor.
No, but you can get presumably they had an estimate, the price of the work had increased, and obviously they got an estimate from somebody that, and the estimate at one point was $78,000, and 4 years later was $121,000.
Well, if you look at this court's decision in 5-Star Electric Corp, which I cited in my brief in just 2020, this exact thing happened in a trial before Justice Barak, where it's settled law that merely relying on an estimate for delay damages is insufficient.
Well, but they're not relying on the estimate for delayed damages. They're relying on that estimate for amending their counterclaim to reflect what they expect their actual damages will be.
No, Your Honor, there never was a counterclaim. This is a new counterclaim that they're adding for the first time. And so what they're saying is, well, we have estimate A and estimate B, and if we have to pay more than estimate A, we've been damaged by the delay. And first of all, they haven't had to pay more yet, so these damages are unripe. They're purely speculative.
In the 5-Star case, you mentioned that that was at the trial stage?
Correct, Your Honor.
Is this case at the trial stage?
No.
So then why wouldn't...
Nowhere near trial.
Why wouldn't the counterclaim be allowed?
Because the classic test for whether a claim is meritorious...
Or I guess my question rather is, then why are you relying on the 5-Star case?
Because it says, first of all...
They're in different postures.
Oh, no, Your Honor. The test for a motion to dismiss is whether if all the allegations in the complaint were proven true at trial, would the party be entitled to a judgment? And in 5-Star Electric, this is what happened. They had the same allegations. They were proven true at trial. Justice Barak gave them a judgment, and this court reversed because it was solely reliant on the lower estimates.
So, counsel, that's not the standard on a motion to amend. It's liberally construed, and unless it's grossly non-meritorious, we don't permit it. We don't test the allegations of the complaint to the extent you just discussed. This is not a 3211 motion or a 3212 motion or a trial. It's liberally construed, and it's permitted. Even after trial, you can do that.
I disagree strongly, Your Honor. Settled law in this court is that if the amendment, if the proposed new claim would not survive a motion to dismiss, that it is futile and should be dismissed. The idea we don't test the allegations of the amendment goes back to the days when you...
I don't think you heard what I said. I said it's liberally construed. And that's what I was trying to say. There's no trial yet. And on a 3211 motion, there's a different standard. And if it's futile, you're correct. But here, it's not futile. They said it went from X to Y, and there's nothing refuting that.
Well, if you can't liberally construe something to add facts that aren't there, that's all I'll say about it. Now, I have two other orders to...
Thank you. Well, you'll have to talk about them on rebuttal. Thanks.
In a lot of years.
That is very true, Your Honor. May it please the court, my name is Daniel Kotler from Western Schwab, Katz & Dwyer, on behalf of defendants and respondents, the Hovnanians. I think Your Honors understand the issues in terms of the motion to amend. This clearly came out of the 4 years of delay and radically increased damages. There's no question that
I mean, 78,000 to 121,000 is not such a radical increase.
But it is an increase, and there are other increases in this case that are clearly referenced and being addressed. We have the massive increase in the overall damages. We have the general issue of...
And those damages, the 500,000 to 9 million, address the structural damages?
I will pull out the exact... If I can find it in a moment. Apologize.
It's all right. Why don't you continue?
I thought I had flagged it, but I don't have it in front of me. But yes, Your Honor, I believe it is addressed, and to the extent plaintiffs complain that the counterclaim is perhaps inartfully, I disagree that it's inartful, but clearly their claim is there. In terms of discovery, there's nothing that defendants can know because the issue is dealing with plaintiffs' delays and plaintiffs...
It's what they've done. It's what they've done or not done.
Exactly, Your Honor. Exactly, Your Honor. And then on the final point, I think this is clearly an unappealable motion for re-argument, which even if it were appealable should be denied because the motion court addressed this issue repeatedly. Plaintiffs drafted the original specific performance order. Then it was addressed again when it was amended, and plaintiffs sought to seek soft contents remediation. Although the court amended it, the court denied both motions and did not add remediation of soft contents, did not change that part. Plaintiffs try to argue this isn't re-argument because it's a new order, not a motion to amend, but they're seeking a new order that contradicts the previous order that they wrote. So,
have they, as part of that motion, established precisely what their costs are for those repair of soft damage?
No, Your Honor. There are attempts to hint at things. One good example of this is the cleaning. There was a dry cleaner, which would not allow, they actually refused to provide an estimate. They said, well, you have to pay the $1,000 deposit, and this is getting into settlement, which is an issue, but the context was we actually offered to pay that $1,000 and plaintiffs wouldn't accept it, even to find out what the amount would have been. Because if it ended up being a reasonable, maybe we could have at least settled that issue. But we don't know. We have some suggestions, but we don't know exactly what the ultimate number would be. And this is obviously an issue of damages for trial. Seeking no other questions, I'll rest my papers. Thank you, Your Honors.
Thank you. Let me move on quickly to the discovery order. The Hovnanians brought a new claim in this case after party discovery had ended, and now they don't want to be deposed again. They don't want to provide any more documents. They just say, oh, we don't know anything. But in their counterclaim, they say specifically that they were at all times ready, willing, and able to comply with the specific performance order. And now they're refusing to provide any discovery whatsoever to support that assertion. So ask yourselves, Your Honors, when they get up...
Wait a second. You have changed some of the information. You had it at 78, you've gone to 121. There are questions from 500,000, it's gone over. They're the ones who are seeking the discovery.
Oh, not at all, Your Honor. They're both sides are seeking discovery.
No, I understand.
We're saying that they caused the delay. They're saying.
But you want to depose them about things that you've done.
Right, exactly.
We can depose them about things that they've done. They were the ones who were ordered to do it. We say that they were the ones who delayed. We give examples of them refusing to pay bills. We've given examples of them refusing to send complete payments. We've given an example of them sending a threatening letter to our contractor saying they're only going to pay half and reserving the right to sue the contractor, which then caused the contractors to stop working. We've given an example of them blaming their insurance company for problems that they've been having. We're entitled to discovery to find out what part of the delays were caused by them and their slowness in payment and their unwillingness to pay reasonably.
Didn't they send checks that were never cashed?
They say that. They didn't send them to us. They sent them to their lawyers and were never cashed. We're entitled to discovery about
Is
that.
this a 2016 case?
Yes, it is.
Do you want it to go to trial?
Yes, it's going to trial later this year.
Okay. Congratulations.
And now, finally, on the counterclaim, on the third order, I just want to read some things that the judge said on the record. This is SR 2144.
Your time is up, so I'll hear this and then.
She says, I am interpreting this being the specific order, performance order that they rest on, not to address the issue of remediation, because I don't think it was really in anybody's mind when 853, that's the order, was discussed. So it really doesn't address it. So I don't think a motion to vacate works. It's really an issue that hasn't been addressed that we need to address. She says then on page 2146, I will take a late summary judgment motion. The good cause will be the conflicting letters and the fact that it's the court's fault that I didn't realize. You can blame me, all right? And then finally on the next page, she says, it's really just a piecemeal summary judgment issue which I have much more discretion to allow, and I will allow it in the interest of judicial economy and moving the case along. This was the motion to re-argue. This was the motion to reconsider. This was a motion for summary judgment. The judge recognized it in statements that she made on the record. We've explained in our brief why it should be viewed that way by this court as well. And I think that all three orders should be reversed. Thank you.
Thank you. Thank you all.
Questions, Your Honors?
No, thank you very much.